Assalamualaikum and a very good day. My name is Misha Nadira binti Muhammad Sofyan and I will be presenting the facts of the case as the starter of our presentation. First and foremost, the allegations in each petition were about the same acts of oppression committed by the common directors of two related firms, ICB-GRIFFIN Manufacturing Syndrome Berhad and ICB-GRIFFIN Marketing Syndrome Berhad respectively, which the petitioner believed were carried out on his behalf by the directors of Instagreen Corporation Berhad and ICB Machinery Syndrome Berhad. For the second fact, the petitioner agreed to sell his intellectual property for $2 million and his machineries for $300,000 in exchange for a 49% equity stake in each of the two related companies to be founded later for the purpose of manufacturing and selling motorcycles in Malaysia. Next, under the ICB-GRIFFIN Manufacturing Shareholders Agreement and the ICB-GRIFFIN Marketing Agreement, it is stated that in each of the companies, the petitioner will have the right to appoint 2 directors to the board of directors, while ICB Machineries will have the right to appoint 5 directors.
Assalamualaikum, my name is Nurul Natasha. I'm gonna talk about the main issues of the case. The first issue is about the allotment of share capital. The second issue is about the appointment of 5th director. And lastly, the final issue is about the obtain of the loan. The first issue is about the allotment of share capital, whether the directors will be held liable for the breach of the shareholders' agreement. According to the shareholders' agreement, the petitioner was qualified to receive 49% of the ordinary share in marketing and manufacturing, and to be selected as director along with one other individual nominated by him in both companies by 8th of November 1996 or latest by 21st of December 1996. In violation of the agreements, machineries acting on Instagreen's orders passed the shares to the petitioner only in late July 1967, and the share certificate were only physically given to the petitioner in early August 1967. Petitioner and his candidate were appointed as director of the two companies only after the petitioner had given notice of intent to sell his stock as a result of the respondents' directors' acts of injustice and lack of fiduciary responsibility. Furthermore, the petitioner argued that the respondents' explanation that the postponement was caused by the need to wait for the Minister of Finance Foreign Investment Committee, which is FIC, to authorize the petitioner's and his nominee application to be appointed as directors was without substance, since no such approval was needed. Second, even though the FIC approval was needed, it was argued that there was no justification why the shares could not have been transferred immediately following the 11th of April 1967. The second issue is about the appointment of 5th director, whether the appointment of the 5th director was done in good faith. In the shareholders' agreement of the two companies, which is manufacturing and marketing, the petitioner will be able to name 2 directors to the board of directors, while ICB Machineries will be able to appoint 5 directors in each of the companies. The issue arose on 10th of June 1967 before the shares may be allocated and the petitioner and his candidate selected as director of manufacturing and marketing. The 5th respondent was appointed to the Board of Directors of Manufacturing, Marketing and Machineries by the 4th, 5th, 6th and 9th respondent in bad faith and without the petitioner's consent, and at the same time excluding petitioner from their management in order to secure a loan. The final issue is about obtaining a loan, whether the directors of the both companies can be held liable for the breach of their fiduciary duty. Without the petitioner acknowledgement or approval, the 4th, 5th, 6th and 9th respondent obtained a loan of 2.5 million for manufacturing and another 2.5 million for marketing from Oriental. Therefore, Instagreen and its other subsidiaries used the total sum of the loan of 5 million to pay off their expenditure and debts. Respondents were aware that the loans were not meant for the gain of the two firms and both of the companies were not able to repay the loan. The directors then breached their fiduciary responsibility to the both companies manufacturing and marketing and jeopardizing the petitioner's right as a minority shareholders. Both manufacturing and marketing were insolvent as a result of the 4th, 5th, 6th and 9th respondent actions in taking the 5 million loan.
Assalamualaikum, my name is Farsa Atika binti Razali. For the first part of judgment and discussion, we will discuss the law that is applicable to the case. So this case is related to the principle of separate legal entity, which is one of the effects of incorporation. This principle is also known as the veil of incorporation. According to Section 20, Subsection 1, Subsection A of Companies Act 2016, a company is a body corporate and shall have legal personality separate from its members. Further provided by Section 192, Subsection 1 of Companies Act 2016, a member shall not be liable for company's obligation by reason only of being a member of the company. This means that a company is fully liable for any of its debts. However, there are few exceptions toward this principle where some circumstances allow the veil to be lifted, which means the members, officers, and company will become one single body. Hence, the company is no longer a separate entity, and the members or officers will be held liable for any offences done if found guilty. The first exception is statutory exception, which circumstances that have been specifically stated in Companies Act 2016. First, the veil of incorporation can be lifted when debts contracted at the time the company has no ability of repayment. The second exception is judicial exceptions. It is a court's order to lift the veil of incorporation. The court has the discretion to lift the veil in such situations when the company is used to evade legal obligations, commit frauds, or improper purpose. Moreover, the veil of incorporation can be lifted when the court is asked to promote justice or exercise an equitable discretion. So for the case of Edmund Charles Liebenberg, we will apply the principle of separate legal entity and also its exceptions.
Assalamualaikum, my name is Fakia Anika. I will explain about judgment and remedy of this case. The first issue is Instagreen engaged in an illegal act by intentionally delaying the allotment of shares and not allowing the petitioner to have two seats on the board of two companies which are manufacturing and marketing. The court has ordered the respondents to buy all the shares in the both companies on a joint and several basis. The order was made on the basis of the petition moved by the petitioner's lawyer, Mr. Anatom. The court has also ordered the parties to agree on the valuation of the shares at the time of their incorporation. A 10% premium would be attached to the valuation of those shares, and the petitioner is entitled to charges. The next issue is obtaining a loan that resulted in conflict of interest. The court answered that these were acts which determine the underlying legislative purpose of providing a company with an independent corporate personality. So it is sufficient to justify the lifting of the corporate veil to make Instagreen and its subsidiaries machineries liable in their corporate capacity for the operation of their director upon the petitioner. This is because all financial decisions were made by a team under the financial controller of Instagreen and were all made in the interest of the Instagreen, and the decision to take the 5 million was a decision of Instagreen.